my birthday was yesterday. Stuart just celebrated his birthday, and to try to convince myself that I'm not middle-aged, I go on a ridiculously long hike on my birthday to my wife's chagrin, and it always has the opposite effect because I end up proving I am indeed middle-aged and out of shape. But on this occasion, I ran into a mountain lion who proceeded to circle me until a ranger came and rescued me. So it was the ultimate demeaning experience to amplify my age. Well, on that inspiring note, the issue of executive overreach is obviously not new, and President Obama is certainly not the first president who can be accused of violating the separation of powers. There is an irony, of course, because I don't think that George W. Bush was necessarily any more inclined to respect the separation of powers, but the irony is that he didn't really have to circumvent Congress, because after 9/11, Congress basically did give him much of what he wanted in areas that were very controversial. But what we have, I think, in terms of what concerns us, was really captured in the last State of the Union. There are many times as a Madisonian scholar where I'm watching TV and I'm just left scratching my head at what I'm watching. And that moment came with the State of the Union when President Obama went to Congress and said that he intended to circumvent Congress and to act alone in areas where Congress has either blocked him or failed to act. Now, that alone was quite surprising, but what was more surprising is the response, which was rapturous applause. And I looked at this body of both houses applauding a president who just said he would circumvent them and act unilaterally, and they had this rapturous applause. It bordered on self-loathing. It bordered on something that I don't think that the framers would have anticipated. And Stuart has laid out exactly why what's happening today, in my view, is different from the past. I think that it's not that we haven't had circumvention of Congress in the past, but it has accelerated under this president to a point that I've described in previous testimony as reaching a certain constitutional tipping point. Our system is changing in a very fundamental way, in my view, a very dangerous way. You know, we have a system which was designed by Madison primarily and others where the three branches are held together in a type of orbit. They are equal in the constitutional sense that they check each other and create stability through that check and balance system and through that separation of powers doctrine. What's happened is that the executive branch has steadily concentrated or aggregated power to a point that it's created instability. And that can be very dangerous in our society because the separation of powers is often misunderstood as protecting the privileges of the branches. That's never what the framers envisioned. The framers viewed the separation of powers as protecting individual rights. The thing that they feared the most was the concentration of power by any single branch. And that is what we're seeing, and that's why we're seeing a fundamental change. The executive branch is becoming a government unto itself. And this includes the shift of power towards federal agencies, which are exercising now judicial and even legislative powers. We recently had the Supreme Court say that agencies could even define their own jurisdiction, something that we considered to be previously a bright line. Now, I have never said that President Obama is a dictator. I don't think he is. I don't think he wants to be a dictator. But I do believe that what he is doing through the circumvention of Congress is making him the very danger the Constitution was designed to prevent. It was designed to avoid. He is becoming a government unto himself. And that may be popular to people who like what he's doing. And I must say, I agree with many of his policies. But that doesn't matter. Because once, power acts like gas in a closed space. Once the space expands, the gas fills it equally. The next president is not likely to give up these powers. And I believe those people who are applauding the president today will rue the day that they remain silent in the face of this change in our system. While the president is suspending things of the ACA or immigration, the next president could do the same with environmental law or employment discrimination. And when that happens, it'll be hard for people to object who are silent today without appearing to be the height of hypocrisy. Now, we've already gone through the list with Stewart about many of these issues, but what strikes me as the most significant is that many of these changes, like the DREAM Act, ACA, involve changes that were rejected by Congress, where Congress refused to act, and the president responded by carrying out the very same decisions or policies under his unilateral authority. And they stretched the gambit of legislation, from the DREAM Act to No Child Left Behind to the Wire Act. These are all changes that Congress had refused to make and the president made on his own authority. Now, the problem, of course, that we often face, I represented members of Congress opposing the Libyan War, is that courts will say, well, you've got the power of the purse. But what's really, I think, unsettling about what we're seeing is that the power of the purse has become almost an urban legend or a constitutional legend. Because of the way we now handle budgets, there is so much money sloshing around in the executive branch that Congress really has lost that power of the purse. A good example is what President Obama did with ACA. When he wanted to change the way the ACA was working, he took $454 million from a dedicated purpose and simply shifted it over on his own authority to a new purpose. Even a Democratic member referred to this as a violation of both the letter and spirit of the law. In Libya, when we were in court opposing the Libyan War, and I was representing both the Republicans and Democrats, not only did President Obama say that he alone defines what a war is, there was no room for the court, no room for Congress. As long as he didn't call it a war, it would not trigger the Constitution. But what was really unsettling was that he funded that war entirely out of discretionary funds. He actually carried out a war without having to go to Congress at all. Recently, when Congress eliminated a certain office at the State Department, they simply changed the name of the person, kept his staff and his functions, and funded it again through discretionary funding. So many of the guarantees that we talk about in terms of the power of the purse have proven to be easily circumvented and, frankly, not a significant deterrent in some of these areas. So the question that we have is not whether President Obama is a dictator, and it's not even about President Obama. It's about our constitutional system and whether we're going to take note that it's changing, and whether we're ever going to have the debate of how those implications should be addressed. In my view, this system is changing so fast and so significantly that I'm not too sure what system we will be left with, except it will be a top-heavy executive branch system. That system will be insulated from the type of public opinion and influence that we have in Congress. While all branches are equal in the Madisonian system, like Animal Farm, some branches are more equal than others. The Congress, for all of its faults, is the thumping heart of the Madisonian system. It is where the Madisonian magic occurs. It's where disparate factional interests become majoritarian compromise. If you take it out of the mix, you create the very danger we had hoped to avoid. Now, it is not enough for people to make reference, as the president did, and I'll close with this, that we are living in poisonous political times. This Constitution was written during poisonous political times. The framers knew about it because they lived in it. This was a time when they weren't just fighting, they were trying to kill each other through the Alien and Sedition Act. This was a time when Jefferson would call the Federalists the reign of the witches. These are people who knew about poisonous politics. They designed a system to deal with it. There's nothing new about that. And it is no excuse to go outside this system. We have a system that is sort of the all-terrain vehicle of constitutional systems. It can go through anything you put in front of it. The only thing you can't do is go outside the rules. And that's what's happening here. And I believe it's dangerous. And I believe that is something that we should be able to agree on, whether we are conservative or liberal or Republican or Democrat. Thank you.
Well, first I want to thank the Federalist Society for inviting me to participate today in this conference and on this panel, and it's a real privilege to be up here with the other panelists. I'm particularly glad Jonathan was able to escape the mountain lion yesterday to join us. You know, I may not agree with the other panelists on the stage about much, but I think that one thing we can all agree on is that the topic of today's power, the scope and the limits of executive authority is a very important one, and that's only becoming more true in today's age of legislative gridlock, where there's just not a lot that's happening on Capitol Hill, and so executive action or inaction is becoming an even more important issue. But with that said, I do want to push back on a couple of the premises of the panel. Suspension of the laws, what are the limits of executive authority? Now, the title obviously suggests that President Obama has been suspending laws, and I believe the description of the panel accuses him of taking, quote, less than vigorous action. And I think both of those premises are wrong, and so I want to take a couple moments to explain why that is. First, it is simply just not the case that President Obama has not been enforcing the law. And I'll just touch on quickly a couple of the examples that Stuart and Jonathan have already talked about, and I'm sure we'll talk about others in the course of the discussion later this morning. So first, the Defense of Marriage Act. As I'm sure most people here know, President Obama concluded that the provision of DOMA that defined marriage to be a union of a man and a woman for purposes of federal law was unconstitutional. And so he instructed the Department of Justice to stop defending the law in court, just as other presidents have done in similar circumstances across administrations. But the decision not to defend the law is very different than the decision not to execute the law, for reasons I'm happy to discuss during the Q&A. And in fact, the executive branch here never stopped enforcing DOMA, not until the Supreme Court concluded that it was unconstitutional. So to me, this is a very odd example of executive inaction because the president continued to implement the law. Another example where the president has taken some heat that's already been mentioned, immigration. Specifically, the president's decision to defer removals of undocumented immigrants who came to the United States as children. But in fact, the administration has been enforcing the immigration laws. It's in fact been deporting individuals at record levels, approximately 400,000 people annually, compared to just a little over 150,000 in 2002. And tellingly, Congress has only provided resources to cover 400,000 removals per year, which amounts to less than 4% of the total estimated population of undocumented immigrants. Given that, the president has no choice but to make decisions about who to prioritize in terms of removal. He can't actually remove every person who's in the country without documentation. Congress clearly doesn't expect him to do so. And so all he's doing is prioritizing removals, exercising prosecutorial discretion. It's certainly true, as both Stuart and Jonathan mentioned, that Congress has rejected the DREAM Act, and that would have done by statute much, although not all, or would have done more than what the president is doing by executive action. But that can't possibly affect the constitutionality of what President Obama is doing. It can't be that the constitutionality of executive action turns on whether Congress has considered legislation that touches on the same subject. What's critical is what Congress hasn't done is it hasn't passed an anti-DREAM Act. It's never prohibited the president from doing what he's doing now, which means he enjoys broad discretion to enforce the immigration laws and decide who should stay and who should go. And that leads me to the second problem with the premise of the panel. And I think it's actually the more important one because it really goes to how we think about and how we analyze these actions by this president or by any president. Now, critics of the president, including both Jonathan and Nick, have attacked him for executing executive authority in a host of different areas: immigration, criminal law, environmental law, just to name a few. But across all of these examples, and all of the ones that have been mentioned, the president is not refusing to enforce the law. What we have is disputes about how best the president can enforce the law. But the idea that the president and the executive branch would exercise discretion in determining how to enforce the law, or that he would interpret the law and give it meaning when there are broadly written statutes, is completely unexceptional. I mean, Jonathan mentioned a constitutional tipping point, but in fact, prosecutorial discretion, administrative deference are both long-standing practices that have consistently been recognized and accepted by the other branches. And the history of the Constitution actually tells us a lot about why that's so. It's certainly true the framers, when they were drafting the Constitution, did not want a king. They did not want a monarch. That was why they declared independence from Great Britain. But their relationship with England was not the only thing that shaped the drafting of the Constitution and the way they thought about the proper framework for our new government. They were also critically shaped by experiences under the Articles of Confederation, which, as everyone here knows, was the precursor to the Constitution, and which lasted just 8 years. And one of the central weaknesses that contributed to the demise of the Articles of Confederation was the absence of an executive branch capable of enforcing the nation's laws. So when the framers gathered in Philadelphia, when they drafted our Constitution, they wanted a strong executive branch headed by a single president. They gave this new president a number of express powers and responsibilities, including the authority and the obligation to take care that the laws be faithfully executed. And so, while they didn't want a monarch, they recognized that a strong president capable of unilateral action was no threat to the republic. In fact, it was essential to the republic. Alexander Hamilton may have put it best when he said that all men of sense will agree in the necessity of an energetic executive. And he said that a feeble executive implies a feeble execution of government, and a government ill executed, whatever it may be in theory, must be in practice a bad government. So the ability to determine how to enforce the laws and what the law means are long-standing manifestations of the president's responsibility to take care that the laws be faithfully executed. It's in the language itself. How do we faithfully execute the law requires determinations about how the law can best be enforced. As then Justice Rehnquist, no liberal after all, wrote for the court in Heckler v. Cheney nearly 30 years ago, an agency's decision not to prosecute or enforce a law is one generally committed to an agency's absolute discretion. After all, as he explained, the executive branch is in the best position to weigh competing priorities and determine how best the law can be enforced. Indeed, as I said, this authority derives from the Take Care Clause itself. Now, some of President Obama's critics have suggested that, sure, discretion is okay, the president can exercise discretion, but it must be exercised on an individual, case-by-case basis. But if the president can exercise discretion, there's no reason why he can't elaborate and articulate rules to guide that discretion. In fact, I would think it'd be much better for him to articulate rules, which means the discretion can be equitably and fairly exercised, and would ensure there's transparency, so both the people who are affected by the rules and the general public understand how the law is being enforced. It's of course true that a president can go too far, and we can have debates across specific contexts about whether President Obama or other presidents have gone too far in any particular instance. But as Justice Rehnquist recognized in Heckler, a president only goes too far if he consciously and expressly adopts, in Justice Rehnquist's words, a general policy that is so extreme as to amount to an abdication of his statutory responsibilities. For much the same reason, courts generally defer to executive branch interpretations of the law, where there is, as we all know there often is, ambiguity in the law Congress has passed. Again, administrative agencies bring to questions of implementation and interpretation and expertise that makes them particularly well positioned to fill gaps in complicated statutory schemes. As Justice Scalia recently said, this is a stable background role against which Congress legislates. It knows that the executive branch is going to fill in gaps, is going to interpret where there's ambiguity in the language. And as he said, Congress knows to speak in plain terms. When it wishes to circumscribe, it can do so, and it can speak in capacious terms when it wishes to enlarge agency discretion. So this long-standing discretion means that President Obama is not, as Jonathan suggested, arrogating power from Congress. He is simply exercising the power that Congress has given him, either implicitly or explicitly. And so in any given case, people can disagree about just how much discretion the Congress has given the president. But as a general matter, and in the absence of specific statutory constraints, the president has wide discretion to determine how to enforce the law and to determine what the law means. So to conclude, I just want to return to the question posed by the topic of the panel. What are the limits of executive authority? It's a simple question, but it really defies simple answer, because the limits of executive authority are going to depend critically on the specific statutory scheme and the specific powers at issue. Suffice it to say, for now, President Obama has not been abusing his executive power. He's simply been exercising it. And the framers of our country, the framers who drafted our Constitution and drafted the Take Care Clause, would not be at all surprised that he's exercising his executive power in this way. Frankly, they'd be surprised if he didn't. So I look forward to the discussion. Thank you.
Great, thanks very much. I'm delighted to be here. I agree with virtually everything that Jonathan said, and actually a few things that Brianne said as well. I'll agree at the outset that the question of defending the Defense of Marriage Act is a different question. I think it's an interesting question, but it is not quite a question of suspension of law. So I'm going to agree about that. And then I'm also going to agree on a much more important point, which is that there is a difficult line here to be drawn between prosecutorial discretion on the one hand and suspension of the law on the other hand. But I'm going to weave that thought into my remarks here. I'm drawing on congressional testimony that I gave on this topic 3 months ago with Jonathan. I'm a textualist. I like to begin with the text of the Constitution. You've heard it a few different times, but I like to focus word by word. So the president shall take care that the laws be faithfully executed. Can we wring any meaning out of these words before we get to political theory? I'd say let's notice a few things about them. First, shall, right? Shall take care. This is not optional, this is mandatory. Second, note that the duty is personal. The president shall take care that the laws be faithfully executed. The duty is the president's alone. Now, other folks are going to do the executing, right? Other folks, the president's got thousands of minions. They're going to do the actual executing, but his duty to take care that the laws be faithfully executed, that's non-delegable. That is a personal duty of the president. And then third, notice, and Brianne's going to agree with me about this, he is not required to take care that the laws be completely executed. And the reason is that would be impossible. That would be impossible given finite resources. The president does have power to make enforcement choices. However, he has to make them faithfully. So it's going to be important to figure out what that word means. And then finally, it's important to remember the historical context of this clause. English kings had claimed the power to suspend the laws unilaterally. The framers expressly rejected that practice. That's what this clause is doing here. The executive would be obliged to take care that the laws be faithfully executed, and that was going to be a big difference between this government and the government the framers left behind. Now, with these principles in mind, we can try to look at some of these recent controversies through the proper constitutional lens. I'm going to focus on 3 of the examples that you've heard referenced already. The Obamacare example, the immigration example, and actually one you haven't heard mentioned, the IRS targeting of the president's political adversaries. Okay, so the Obamacare suspension on July 2nd, 2013, just before the long weekend, the Obama administration announced via blog post that the president would unilaterally suspend the employer mandate of Obamacare, notwithstanding the unambiguous command of the law. The statute is perfectly clear. It provides that these provisions become effective on January 1, 2014. Now, I have lost track. The president has suspended or modified Obamacare some, is it 36 times or something by now? I've actually lost track. But I like to focus on this one example because Brianne says sometimes Congress leaves gaps, sometimes the language is ambiguous, sometimes Congress wants for the president to fill in these ambiguities or fill in these gaps. This is not such a case. The date is crystal clear. January 1, 2014. It could not be more explicit, it could not be more clear, and you don't need a lawyer to understand what it means. This blog post, though, written under the breezy Orwellian title, quote, "Continuing to implement the ACA in a careful, thoughtful manner," close quote, makes no mention at all of this statutory deadline. Okay, so the blog post raises the question of what this adverb faithfully means. Again, the president has broad discretion about how to deploy executive resources and so forth, but this breathtaking blog post is not a mere exercise of prosecutorial discretion. This is wholesale suspension of a law in the teeth of a clear statutory command to the contrary. Whatever it may mean to take care that the laws be faithfully executed, it simply cannot mean declining to execute the law at all. So as if this suspension weren't enough, I'd say the president's comments about it were particularly troubling. So On August 9th, 2013, the president said that, quote, the normal thing that he would prefer to do, close quote, is to seek a, quote, change in the law. That's what he would prefer to do. He said, but the president actually was, he said he would prefer to just pick up the phone, I guess, and ask for a change in the law. He'd prefer to, quote, simply call up the Speaker of the House to request a, quote, change in the law. But apparently he couldn't do that because the climate is so toxic, the partisan climate. So he couldn't do that. The truth, though, is that as the president knows, he wouldn't even have had to pick up the phone because there already was a bill that would have done this exact thing, that is, suspended exactly the provision he wanted suspended, and the president didn't actually support that bill. To the contrary, he actually threatened to veto it. So it's really almost the president actually seeming to prefer flouting the law as written rather than supporting a statutory change that would achieve his desired results. This actually seems to me almost a willful violation of the Take Care Clause, really. Okay, so that's example one, Obamacare. Second is the immigration issue. You've heard it referenced. So what's interesting here is it's almost a mirror image. Here Congress actually considered this bill, the DREAM Act, which would have exempted certain folks from a broad category of aliens from the Immigration and Nationality Act. The president favors this act, and Congress repeatedly declines to pass it. So on June 15th, 2012, the president announces that he'll simply not enforce the INA against the precise category of aliens that are described in the DREAM Act. He announces, in effect, that he'll act as though this statute had passed. He'll behave as though this were the law. Now, once again, I'm going to agree with Brianne that the president has broad prosecutorial discretion, broad discretion to husband executive resources and so forth. But in this case, it's quite clear that he's not just trying to conserve executive resources. How do we know? His Solicitor General recently went to the Supreme Court to forbid Arizona from helping to enforce the INA, right, which is free for the federal government. He said, no, you can't do that either, and exempted 1.76 million people from the immigration laws. And I want to say this goes far beyond any traditional conception of prosecutorial discretion. More to the point, this exemption has a distinctly legislative character. It's not a decision in a particular case, we don't have enough evidence as to this person, or it would cost too much as to this trial or something. This is a blanket policy as to 1.76 million people, and it's exactly a policy that Congress had declined to pass. To put the point another way, returning to the text, the president shall take care that the laws, capital L, be faithfully executed, not the bills that fail to become law. Right? Not the bills that fail to become law. Here, in effect, the president's faithfully executing the DREAM Act, which is not a law at all, rather than the INA, which is supreme law of the land. And of course, most strikingly, the president made this exact point 20 months earlier. Quote, America is a nation of laws, which means I, as the president, am obligated to enforce the law. With respect to the notion that I can just suspend deportations through executive order, that's just not the case, because there are laws on the books that Congress has passed. There are enough laws on the books by Congress that are very clear in terms of how we have to enforce our immigration system, that for me to simply, through executive order, ignore those congressional mandates would not conform with my appropriate law as president. I couldn't have said it better. That's President Obama, 20 months before making this decision. Okay. Third example, and I'll be very quick, IRS targeting, and this is not an example that people have really talked about in these terms, so I do want to get this out on the table. I think you're all familiar with these facts, but just to put this in terms of the Take Care Clause, the president has, of course, tried to distance himself from this scandal, right? I knew nothing about all this, but again, I want to remind you, the duty to take care that the laws be faithfully executed is personal to the president. Execution of the laws can be delegated, but the duty to take care cannot. For this reason, quite what the president knew and when he knew it is, in a certain sense, beside the point. The point is, he should have known. He should have known. It won't do for the president to say erroneously that the IRS is an independent agency, as he said, nor will it do for him to say that he learned about IRS targeting from the same news reports as the rest of us, close quote. Not knowing what an executive agency is up to, let alone not knowing that the IRS is actually part of the executive branch, is not taking care that the laws be faithfully executed. Now, again, to return to Brianne's point, yes, faithfully includes a concept of prosecutorial discretion. The laws cannot be completely executed. So let's take a clean example. Congress criminalizes bank robbery. The president can certainly say, look, I don't have the resources to prosecute every single bank robber, and so I'm only going to prosecute the big bank robbers or the violent bank robbers, the repeat bank robbers, things like that. Of course the president gets to say that. He does not, though, get to say things like, I'm not going to prosecute the Catholic bank robbers or the black bank robbers or the Republican bank robbers. He doesn't get to say that. And what I want to say is the religion example, I won't prosecute the Catholic bank robbers, that would have horrified the framers, the thought of a president doing that. But I think there's an example that would have horrified them even more, which is declining to execute laws against his political friends, only against his political adversaries. I think nothing would have troubled them more than that. The single most corrosive thing that can happen in a democracy is for incumbents to use the levers of power to stifle their critics and entrench themselves. I think that would have been absolutely the paradigm case for the framers of unfaithful execution. So I think they would have been deeply worried about that. I think I'm going to abate there and keep going with questions and answers. Thanks.
Thank you. I have some questions for the panelists. I'm going to resist the temptation to ask Nick, well, what about suspending the enforcement of the laws against the 1% bank robbers? First, Brianne, I'm curious whether the logic of your analysis would support the kind of impoundment of appropriated funds that President Nixon did, and how you would respond to Jonathan, in particular, his concerns that, well, under the logic of what President Obama has done, a Republican president could suspend more provisions of the ACA, could suspend environmental provisions, could suspend discrimination provisions, that he's creating a precedent that would come back to haunt his party. What about all that?
Well, as I said in my remarks, I think what's really critical to remember is there is no one categorical answer that's going to apply against all examples and all questions. And I think, Stuart, your question really highlights the difference between what is going on in the implementation of the Affordable Care Act and some of the other hypotheticals that we might think about Republican presidents who don't like it at all. Mitt Romney saying that he would, by waiver, get rid of it basically altogether. As Nick said, one of the backdrops of the drafting of the Constitution was the concern that English kings would just suspend laws they disagreed with. Clearly, that is not what's going on here. No one thinks that President Obama disagrees with Obamacare. This was his landmark legislation, and what he is trying to do is simply implement it in a reasonable, equitable, commonsensical manner. And what that entailed here was some adjusting of the deadlines as we transition to the new regime. And that is, in fact, a totally common, typical thing that has happened across administrations in the implementation of complex statutory schemes. It happened under President Bush, it happened under President Clinton, and it's happened in other contexts under President Obama. Oddly enough, we don't seem to see the same outrage from the right about delays in implementation of rules related to consumer safety or environmental laws. Yet all the time, we see these kinds of adjustments and transitions as complex laws are implemented. And so that's all we have here, and I think we would have a very different case if we saw a president trying to wholesale suspend a law simply because he disagreed with it as a matter of policy. And so as any hypothetical, it would really just depend on the specifics of the statutory scheme and the specifics of the context. I think for present purposes, what's important is that President Obama is not wholesale suspending the laws, either in the context of Obamacare, in the context of immigration, or in any of the other contexts that have been discussed.
Thanks very much. A question for Jonathan. Understanding that there was poisonous politics at the time of the framing and rivaling today, I can imagine it being argued, in fact, I have seen it argued by, I think, Professor Posner, Eric Posner, that we today need an aggressive, muscular federal government, and that we'll only have it if the president does it, given Congress's inherent limitations, and that differentiates the president. That in effect, if the president observed the restraint that you think they should reserve, we would be incapable of responding to important national needs. How do you respond to that?
Well, I think history disproves that. Some of these arguments that I read border on a form of constitutional defamation. We have the most successful constitutional system in the history of the world, and yet we constantly say things about the system and the failures and limitations, and I include the Bush administration on this after 9/11, that I think is truly otherworldly. This is a remarkably successful system. What it doesn't give you is everything you want. What it doesn't allow you to do is to go it alone. And that's been frustrating for presidents for a long time. And what I would say about the need for a muscular presidency is that is a type of system that moves more swiftly. It's just not our system. And we have to make a decision of what system we want. There's a reason why we are not getting a lot of things done. And this may come as an epiphany for some. We're divided. We're a divided nation. And Congress looks exactly like the nation. It's heated, it's divided, nobody's compromising. That's what Congress is supposed to be. It is supposed to be a reflection of the public. And so when people say, well, we can't live with this, well, what you're saying is that you want to circumvent the representatives of the public because they represent a divided public. Now, when you argue for a muscular presidency, and some people have, as Stewart's noted, you have to keep in mind what that means. Take a look at the Libyan War. There was no issue the framers were more focused on than war powers. They didn't like wars. They didn't like executives getting us into war. They talked about it a lot. They wanted to make sure that Congress would have to sign off on it. Look what happened to Libya. And if you believe that the framers would look at that with any sense of approval, we must be reading different works. Because you had a president who unilaterally decided to attack another nation, whether you like it or not, attack their capital, attack military units, and fund it through discretionary funding, and refuse to accept that either the courts or Congress could define whether that was a war. Now, that's a muscular presidency, just not the presidency that is part of this Constitution.
I'm going to ask Brianne in a minute to respond, especially as to the Libya War. But first, Nick, a question for you. I'm going to read you something Professor Richard Epstein wrote in January about the suspension of the employer mandate, and ask you to respond. Think first, Epstein wrote, of what would have happened if the president had decided to faithfully execute Obamacare in its entirety. Much of the American health care system would have come to a grinding halt. The requirement that the president faithfully execute the laws presupposes, at a minimum, that there is some capacity to implement the rules. It is foolhardy to demand that the president execute the impossible. And he added, as a little twist, we should be relieved that Mr. Obama, having been foolish enough to support the health care reform, had the modicum of humility necessary to suspend some of its most ambitious and perverse provisions. Why is Epstein wrong?
Well, a few different points. One is this act was actually enacted years ago. Hasn't something gone wrong if a statute is impossible to implement with years, literally years of lead time? We couldn't get our act together by January 1, 2014. This was years ago. So I would say that's a bit of an indictment, actually, of the law itself. But as to the example that I gave, again, the striking thing is Congress was prepared to amend this law. The president could have said to Congress, it's impossible to enforce as written, will you please amend it? In fact, there was a bill already that had already passed the House. So at least as to this example, no, there could have been a legislative change, and there should have been a legislative change. The president, far from supporting that legislative change, actually threatened to veto it.
Before we go from that, what was the president's reason, either implicit or explicit, for refusing to sign a statute that, or refusing to support a statute that would have done exactly what he wanted done?
So the explicit reason, or the purported reason, was it's unnecessary. The actual reason almost certainly is that it was politically awkward, and the reason why it was politically awkward is the House had actually passed 2 bills. One of them would have suspended the employer mandate, which is what Obama wanted to do and what he's actually done. The other one would have suspended the individual mandate, which the president didn't want to do at the time, although, as you say, he's now actually suspended some aspects of that as well. So signing the one and vetoing the other would have put him in the awkward position of granting a break from Obamacare for big employers, but requiring the rest of us to comply with these onerous mandates. That would have been politically awkward, and so he preferred to say, oh yeah, actually neither one of those is necessary.
Thank you. Brianne, I'd be interested in your views of the Libya example. Granted, it's a little bit afield from suspension of the laws, unless you count the War Powers Act, which I think every president considers unconstitutional, although none of them quite say so. And also, since you're outnumbered on this panel, within reasonable time limits, any shots you want to take at anything else?
Can I just start with the second of those? Well,
Go for it.
As to the Libya question, I think the Office of Legal Counsel, in their opinion on the topic, made a powerful argument that given the limited nature of the intervention, this was not something that required congressional authorization. But, I'll agree with Jonathan that this is, or partially agree, I guess, I should say this is a closer call than I think many of the things we've discussed today. But, I think that is a question about whether there has been a long-term erosion of the congressional war powers, and that is a much larger, more complicated subject that is, Stuart said, is a little far afield from the examples we're talking about today. And I think what is in some ways so pernicious about the laundry list of attacks against the president for doing things that are totally unexceptional, interpreting the law, deciding how to execute the law, is it distracts from these other conversations that we could be having about areas where I think there is more room for discussion about whether there has been a long-term shift in the separation of powers that would be worthwhile for us to have. And so I will take this opportunity to talk a little bit more about the immigration example that Nick talked about. He mentioned again that Congress declined to pass the DREAM Act, which he said would have done exactly what the president is now doing by executive action. Well, as an initial matter, that's simply not true. The DREAM Act would have, in fact, given people to whom it was subject permanent residency. And of course, the president, by executive action, is simply deferring removal. That is something that could change under this administration. It would almost certainly change, or could change, under a future administration. So to suggest that the president is doing exactly what Congress rejected doing is, I think, wrong as an initial matter. But I also just think it's irrelevant. I don't think Nick would be saying that what the president is doing would be completely constitutional if Congress had never considered this action. So we have to then just assess the president's actions against the context of this specific statutory scheme. And I think there's a very strong argument that given the complicated nature of the immigration laws and given the fact that Congress has not given sufficient funds to execute them completely, the president has to exercise discretion in determining how best to do so. Nick mentioned that the president did not take Arizona up on its offer to help him implement the immigration laws, but of course, Arizona can't supply the funds necessary to completely execute them. What Arizona wanted to do was help direct how the executive branch determined immigration priorities, and that's simply not the state's role. That's the role of the federal government to determine those priorities, and that's why the president challenged and the Department of Justice challenged the Arizona law. And so I guess the final point I'll make is that there still seems to be this agreement that the president can exercise discretion on an individual basis. And if that's so, I don't understand why he can't do it on a role basis and announce categorically what the priorities are. And I'm a little bit surprised by Nick's position on this. I think back during the Bush administration, when signing statements were very controversial, Nick had suggested that it's better for the president to announce and be very transparent about his views on what the law means and what parts of it are unconstitutional. I think you said often that sunlight is very important in government. It lets people know how the rules will apply to them and gives a chance for an honest conversation about what the administration's priorities and beliefs are. And if that was true then, I don't understand why it wouldn't be true now.
Thank you.
Since I have to leave, can I just respond to one thing?
Yeah, and well, I was going to ask you
go ahead. I'm
respond to something else, but respond to whatever you want. But I'm curious whether, since you have a plane to catch, you can have all the time you want. Whatever you were going to say, plus I assume that this in your view, that this presidential encroachment did not begin with President Obama. I'd be interested for a little historical perspective on whether what he's done advances the encroachment or whether it's the same old thing.
Well, first of all, to answer your question, I think that we certainly have to look at this as a trend in terms of the expansion of presidential power. We saw a major expansion under President Bush, and in some ways we've seen the acceleration of that trend under Obama, which is really quite fascinating. I wrote a column. I had to speak at the Watergate anniversary with many of the surviving Watergate figures at the National Press Club. And it was one of those things where I decided not to give the speech that I had been asked to give because I looked out at this audience, at all of these survivors of Watergate, and I said, it just occurs to me, how did Richard Nixon win? Because President Obama is the president Richard Nixon always wanted to be. If you look at the articles of impeachment, every one of those powers he's exercising. And yet, there really isn't a pushback. The best example of that, in terms of the strange scene of Congress applauding a president saying, I'm going to make you a non-entity, was when Attorney General Eric Holder went to my alma mater to announce the kill list policy. And this is an example of expanding on a Bush policy, because Bush did vaporize a couple of Americans. He argued that they were collateral damage to a target. He didn't argue that he was targeting the Americans. And we debated that, and it was a closer question. And then President Obama went further and actually created a system by which Americans could be taken out on his sole discretion. And so you had this Attorney General telling an audience of esteemed judges and lawyers, the president is now asserting the right to kill any one of you on his own authority if he believes you're an imminent threat to national security, without a charge, without any access to the court, and the result was applause. And I remember watching this thinking, we really are living in a parallel universe, that a president is claiming the right to execute American citizens, and there really isn't much of a debate about that. So I think it's really an acceleration of that process. The only thing I was going to mention, I think Brianne has done a fantastic job, honestly. It was very interesting to listen to her. I'm going to just touch on a pet peeve that I have, which I'm going to disagree with. And that is, Brianne said, look, if this was such a circumvention of Congress, why didn't they pass the Anti-Dream Act? And I only wanted to hit that because I just wrote a law review article opposing what's called the historical practice theory, which is where courts say, look, the presidential power appears to be constitutional because Congress has acquiesced. Congress has not pushed back. I'm a strong critic of that view. We wouldn't apply that approach to any other part of the Constitution. We wouldn't say, yes, the president suspended free speech, but Congress hasn't done anything about it. Because Congress may, in fact, agree with the president. It doesn't make it any more constitutional. But more importantly, the reason why the president's circumventing Congress is because Congress is so divided, it can't get a lot done. But that's not, in my view, relevant in terms of evaluating whether he's acting constitutionally. And so I think that Brianne has made some really interesting points. I don't agree with many of them. I agree with some of them. But I just wanted to make that one note, and then I'm going to go and flee to the airport. Thank you so much.
Thank you. Jonathan, please keep your cell phone handy in case the former Assistant Attorney General or Acting Attorney General has a question for you specifically. I'm going to ask one last compound question, beginning with Brianne and then to Nick. Brianne, what is the best example you could give of a Republican president doing exactly the kind of thing that President Obama's doing and Republicans not complaining then? And then I'd like Nick to respond to whatever that is.
Sure. Well, and
But
I just
fairly
want
briefly on this.
Okay, well, just one comment in response to the Anti-Dream Act, although I realize it's not quite fair since Jonathan has had to leave. But I think the significance of that is about the statute. What that suggests to us is that, the Congress, in passing the immigration laws, has given the president broad discretion. And the whole point is that, as a statutory matter, if the Congress wanted to circumscribe that discretion, you could have, put to the side questions about whether it's whether it could do this in the context of immigration, where the president has significant powers, the Congress could do so, and the Congress has not. And so this is a question of statutory law, a question of the president's discretion, and that's the relevance of their failure to pass the Anti-Dream Act or to respond in other cases in which the president is taking actions with which Congress may or may not agree. In terms of your question, I mean, I think one recent example was the Medicare Modernization Act under President Bush, where you had the prescription drug element and other changes to the Medicare law. It was a very complicated change and a very complicated statute. And so several times, I believe, the Bush administration delayed implementation of parts of that to help ease the transition. And there was not, I think, the same outcry that we're having now about what is going on under President Obama. And tellingly, I think that's why we've seen President Bush's, I think his HHS secretary, saying that there is nothing wrong with what Obama is doing with respect to the employer mandate, that this is a very typical, very common thing when you have to administer a complex statute. We want the president to do it in a sensible way that will work, and sometimes that requires adjusting deadlines.
Nick, response?
Yeah, great. First, let me just respond to this Anti-Dream Act business. I would say the Anti-Dream Act is the INA. The INA is quite clear about who gets to stay and who gets to go, and the category of folks described in the DREAM Act, which did not pass, those folks are covered by the INA. You don't need actually another statute saying, we really mean it. We're really actually serious. We really want you to deport those folks. That's what the INA says, period. So I don't understand this Anti-Dream Act conversation, really, just in the same way you don't need an Anti-Obamacare Suspension Act. What you have is Obamacare. And it's crystal clear, and it tells you when it kicks in. The prescription drug analogy, I'm afraid I don't know the facts well enough to comment on it, really. I guess what I would say is, if the facts are as described, I want to object to that as well. I think that if the statute is as clear, if the statute was as clear and the suspension was as explicit, then yeah, I want to complain about that as well.
Thanks. Let's have questions from the audience. I may have a little trouble seeing you because of the lights, but I do see Stuart Gerson rising and some other folks rising, and please, and a line being formed, which is a good idea. I wish I'd thought of it myself. Yes, sir. First in line.
Yeah, hi. I'm David Bernstein from George Mason Law School. So, I tend to agree more with Nick than with Brianne on the general outlines of this, but I think that there's a lot of room for reasonable discussion as to the extent of executive power to modify in ways that are least consistent with the statute's goals, and to delay if there are technical difficulties, if there are resource issues. Congress told us to do this, but we only have $10 billion, and we need $50 billion, so we have to decide. So my question is, though, but the thing I find problematic, especially about the Obama administration on these issues, especially suspension of the ACA, that I don't find with the Medicare issues under Bush or other examples that have been given, is that many of us believe that a lot of the suspensions in this case have happened for purely political reasons. Not we don't have resources, not the whole healthcare system, as Epstein argued, would collapse, but hey, there's a provision coming into effect in October 2016. Wait a second, that's going to be unpopular. And the election's coming up in November. We don't want to lose the Senate, so we better suspend it until after the election. Now, you may not agree, Ms. Gorod, that that's actually what's going on, but can we agree, just in principle, that if it's true that an administration is suspending the laws or delaying laws, not because they can't enforce them or because there are technical difficulties in enforcing them or because they don't have the resources, but for purely political reasons, that would not be faithful execution of the laws, and that would be unconstitutional?
Yeah, I think, it's a little bit difficult to talk that abstractly about the exercise of a presidential power, but, as I've said, I don't think the president can choose not to enforce a law simply because he disagrees with it as a matter of policy. I just think the president has broad discretion to determine how best to enforce the law, and that's what we have here in the case of Obamacare, immigration, the whole litany of examples. But if a president were not doing it because of resource constraints or to facilitate actual effective and in good faith implementation of the law, that would be a very different question.
Now, if I could just ask you to follow up on one thing and then come. What if it's not that he disagrees with the policies, but he doesn't want them to kick in until after the near-term election, because he's afraid it might cost his party votes. Is that okay or not okay?
I think that would probably not be okay, but I don't think that's what we have going on here.
Okay.
Yeah, I think I was going to ask your follow-up question in effect. I mean, David's question is different. Brianne says the president can't decline to enforce the law because he doesn't like the policy, and obviously this president likes the policy of Obamacare, but I would say this is even worse. This is even worse, is declining to enforce a statute, not because you don't like the policy, but because you don't like the politics. And that's what seems to be going on here. It's hard to prove, but it does seem like it.
The Honorable former Acting Attorney General of the United States, Stuart Gerson.
Well, I would feel remiss your having now invited me 3 times to ask a question to a panel that has covered the issue rather well. I would disagree with Ms. Gorod in the sense that I don't think that the war powers analysis is something that can be put aside. Indeed, it's the laboratory to answer the questions that are raised, since virtually every president, I guess Benjamin Harrison didn't last long enough really to have the problem, but virtually every president has been at loggerheads with Congress one time or another with regard to the exercise of war powers and foreign affairs powers. I, of course, if not a primary, am not a primary offender, I'm at least an aider and abettor of the exercise of controversial executive power. I believe that Professor Turley actually sued us or participated in suits related to the Gulf War in the first Bush administration. But in searching for a rule, I would suggest and ask you all to comment on that. I think Mr. Rosenkranz comes closer than anybody in at least defining what a rule might be as a limitation. I mean, the traditional anion to energy in the executive is energy in the electorate. We don't exercise much of that these days. Most of the campaigns have to do with things like the economy, where the executive actually has very little power to affect things, and these important constitutional questions are left behind. But if we look for a rule that gets beyond the political question doctrine that is applied to a lot of this, at least can't we say that the president is not acting as an appropriate executive when he's attempting to enforce non-laws, things that are it can't be said that you're taking care faithfully to execute because they haven't been passed.
Thank you. Any response to that?
I think that's for Brianne.
Yeah, I mean, I would just say, I guess, that I don't know what the scope of non-laws would be. Obviously, there are lots of laws that Congress doesn't pass, and the fact that Congress hasn't passed something doesn't limit the president's authority to interpret and implement and execute the laws that Congress has passed. And, I will say you asked for a rule, and I think it's very difficult to give a rule because I think it varies a lot from context to context what the president can do depending upon the background statutory scheme and the specific powers at issue. But one place where I do agree with Jonathan is that I do think there should be more access to the courts for people to challenge executive action across administrations, and so we can have a fuller and more comprehensive discussion of these issues.
The defect in that, and perhaps Mr. Rosenkranz can comment on it, is when you're offering freer access to the law, when you're getting beyond the political question doctrine, you're suggesting that the courts have that there is a rule that the courts can apply. What is it?
Well, I mean, it depends. It's not so much a rule as looking at the specific statutory scheme, looking at the statute and its language and what kind of discretion it gives the president, and making determinations about whether the president has exceeded that discretion or not.
I should also say, well, I'll make a couple points. One is I do want to separate out the constitutional question from the justiciability question. So it is possible that these constitute constitutional violations of the Take Care Clause, and yet they're non-justiciable. And I'm not taking a position about that here today. These constitutional questions are still worth debating and still worth considering because they should be relevant to actions of Congress, and they should be relevant to actions of the electorate, should be relevant to who you vote for. So whether or not there's ever a case about this you should care about the constitutional question. And then I just want to comment briefly on a point that Brianne's made a couple of times, which I think is interesting and rich, actually. This point about the relevance of Congress failing to pass the DREAM Act. And I will say, I largely agree with Brianne that in general, Congress's failure to act is not usually relevant, or at least it's very tricky to derive anything important from Congress's failure to act. They can fail to act for a variety of reasons. But I think it's relevant here for two reasons. One is, I think it underscores the legislative character of what it is the president's doing, right? So the president is doing a thing which actually looks exactly like a bill, actually looks exactly like a law, and the president himself made that point as to the DREAM Act, right? The president made that point as to the DREAM Act. This is not a thing I can do unilaterally because it's legislative. This has a legislative character. So that's, I think, one way in which it's relevant. I think it's relevant in another sort of subtle way, which is, almost a steal seizure case type of way, right? That the president's power is at its lowest ebb when he's acting against the wishes of Congress. Now, Congress didn't pass the anti-DREAM Act, it's true, but they considered the DREAM Act and decided against it, and I think it is actually relevant for that purpose, in a sense.
Thank you. Next question.
This may get back to, Nick, to your justiciability question, but Jonathan made the point that the power of the purse doesn't seem to be working. So my short question is, how do we solve this problem in the administrative law context when an agency is trying to pass a law? And my experience was at the CPSC. There may be deadlines that you can't meet and so forth, but traditionally federal courts have said as long as you're making adequate progress and doing your best to implement it, then that's enough. They're not going to penalize the agency for missing those deadlines. But this seems different when you're taking a deadline and say we're not even going to try to meet that. We're explicitly going to abrogate that deadline. What can Congress or the courts do about that kind of behavior?
Yep, so again, I've sort of bracketed justiciability, and I have my doubts that there could ever be a case about this, although, so the right set of facts could conceivably present a justiciable case about that, I suppose. But again, I want to say this should be relevant to actions of Congress. Jonathan's right that the power of the purse is not as potent as it once was, and as it probably should be. Congress should probably be more explicit about its appropriations and less tolerant to the president shifting money around. So I think that would be, remedy one. And remedy two is for we the people to be aware of this constitutional issue and to vote based on it. And I think that's actually the most important thing.
And I kind of just add that I think one reason why it is valuable and important that the administration has announced in advance how it's going to implement these rules and where it's going to have delays and where it isn't, is that it facilitates people understanding what's going on and facilitates a conversation about it. And so it strikes me as a little bit odd to fault the administration for planning ahead and recognizing it's going to be difficult to do this given the resources we have and given the complicated nature of the transition, and announcing that ahead of time when that just facilitates a conversation and facilitates transparency, which I would think we would all want.
Oh, and maybe I should just comment on that. Brianne said that a couple of times. Yes, I am in favor of transparency. I'm not complaining about the president saying this. I'm complaining about the president doing it. Right? If he's going to do it, then yes, it's better that he say it than that he not say it. But I'm complaining about him doing it, actually.
Yes, sir. Next.
John Eastman. There's Brianna. You make it sound like this is just kind of commonplace, and there are two aspects of what's going on here that have never occurred before. The first, we've taken this prosecutorial discretion, which applied in limited number of cases, and made it across the board. I think Nick made that point earlier. But the second thing that's happened here that has never happened before is we then use that prosecutorial discretion to alter status in every one of these cases we've been talking about. The DREAM Act case, it's not just exercising discretion not to deport, but giving you a lawful residency status that the statute specifically forbids. In the marijuana cases, not just choosing not to prosecute, but actually pretending like we've eliminated the law when the Schedule I prohibitions of marijuana are unbelievably clear. It's so clear, in fact, that everybody is in chaos about, well, if I make money in this medical dispensary, can I deposit the funds in a bank without all of the bank's assets being subject to seizure? Or for any private individual who has been harmed by that to be able to bring a civil RICO action against the people that the president has decided not to prosecute. He's claimed to give status, the protection from the law, not just prosecution, and that has never happened before.
Now, I see we're running out of time. We have 5 minutes and several more questioners. So I hope both of our panelists can memorize and and retain everything they were just asked. And let's get all the other questions we have time for on the table. Please keep your questions short, and then I'd ask both panelists to respond.
Yes, my question is, what's the relevance of the ultra vires doctrine, particularly on the Obamacare suspension? It would seem a court could declare that the president was without power to do that, and the law would be generally applicable and enforced.
I worked for OMB, and I was in charge of evaluating many of the very large government programs. And in my experience, even in Republican administrations, the amount of effort to enforce or not enforce is massive. It affects major programs like all federal contracts, employment discrimination across the United States. So I think the issue of whether it has or has not been done in the past is, for people who know what's been going on, it always happens. What I found confusing is where to draw the line. Everybody makes a good case, and the topic is where are the limits. So what are the limits?
Thank you, and this may be the last question, and after it, I will ask Nick and then Brianne to respond to all of these questions. Sir.
I'm interested in your thoughts about the Attorney General's decision not to prosecute certain crimes or disclose certain information to the courts. For the longest time, the Justice Department's position has been to prosecute the most serious, readily provable offense. So this was basically codified in Dick Thornburg memo, but the policy goes back decades. The purpose is that Congress has made a number of policy judgments. Any particular criminal defendant could be prosecuted under 30 different statutes, but the idea is pick and prosecute the most readily provable serious offense. And the Attorney General said, you know what, some of these carry too high a penalty. We're not going to disclose the possession amount to the court, which hopefully won't show up in pre-sentencing. So I'm interested in your commenting on that and the conventions and understanding between the branches about how laws are going to be executed.
Thank you. Well, we have all of 2.5 minutes for first Nick and then Brianne to take on all of the questions that are still on the table. Fortunately, that should be plenty of time. Please do so.
Do you mean I have 2.5 or I have 1 1/4?
1 1/4. And I just used up a quarter.
All right, so let me just quickly, I'll actually just try to take on the first two, John Chapman's question and the question about the ultra vires doctrine. I think it's quite right and an important point. The idea of prosecutorial discretion has always been an idea of, has always been a passive idea. And the president can decline to act, can sit on his hands, as it were. That's the prosecutorial discretion idea, and here in many cases the president seems to have gone further than that, actually taken active steps to legitimize a status that is, made criminal or made illegal or whatever under federal law. So that, I think, is an important difference. And it does actually bring into play this idea of ultra vires action, right? Ultra vires doctrine would not come into play if the president were simply sitting on his hands. But to the extent the president's taking active action in contravention of clear statutory text, yes, I think this does raise a different set of questions.
Thanks, Brianne. Unless Jonathan calls in from the tarmac, you get the last word.
So I think I've got about 30 seconds now. So I think the one thing I'll touch on.
Take a whole minute and a
Oh,
quarter.
thank you. I think the prosecutorial discretion, I think the marijuana example, which one of the questioners raised, is a really good example and one that we haven't actually talked about much today, because it is just another example where we have a significant amount of federal criminal law, and it is simply impossible for the president, the executive branch, to enforce all those laws. So of course he has to make decisions about which crimes to prioritize and which not to. And all we have here is the president being very transparent and open about what his top priorities are going to be. And I would think that this is an example, in fact, where folks here at the Federal Society Conference would be happy the president is actually showing deference to state determinations about drug laws, with states that have said that marijuana is going to be legal. The president's saying simply, these are not going to be a top priority for the federal government. And so this, I think, is a prime example that's typical of basically everything we've talked about, where we have lots of laws, we have complicated statutory schemes, and the president is simply making determination about how best to enforce the law.
Thank you both, and please join me in applauding. Thank you. Appreciate it.